WDXE News, on the air since 1951. This is The Legend. 105.3, 95.3, WDXE.
That's us, WDXE, and it's time for Stan Pierchoski and Bulletproof Estate Planning. And glad you're here, buddy. It's been a week since I've seen you.
It has, and good morning, Jeff.
Good morning to you. Good morning to you. Of course, it is Good Friday, headed into the Easter weekend and all that kind of stuff. So,
sure doesn't feel like Easter, but
yeah,
it
kind of got here fast, didn't it?
When it's kind of in March, it feels weird.
Yeah,
it's usually it seems like all my childhood years it was always an April kind of holiday, but it does occasionally hit early in the month. So.
It does. It does. You got big plans?
I got almost zero plans. To be honest
almost
with you.
zero.
We had a wedding last weekend, and
that's
all that.
right.
Yeah,
I hope that went well. I'm sure it did.
Got some family members still at the house. They're going to be heading out on Sunday, Easter Sunday. So,
okay.
So it's that going on, but
yeah.
I have a birthday today that almost got swallowed up. Not my birthday. My other son, the one that didn't get married, his birthday's today, and I want to make sure that doesn't get absorbed by the other events.
Well, you've got a lot going on then. Just family, family stuff.
Normally not, but it's just been hectic.
Yeah,
hectic.
Yeah.
So.
Well, we are here, of course, with you on Fridays, and of course, we talk estate plans, deeds, trust, wills, and today you've been thinking that we may talk about powers of attorney.
Correct.
Yes, and there's a lot of misconceptions about it.
There is, and I could probably fill the whole hour up on it.
But probably could.
I'm just saying there's a lot of misconceptions, things I want to straighten out.
What is it people normally execute a power of attorney? What are some of the reasons that people would want one?
Okay. I mean, it only has one real purpose. And before we get started, I just want to let me mention a couple general things.
Absolutely.
General things. The first general thing I want to talk about is, this is a call-in show. We have some people that do.
Yes.
But if you have a question, that's great. If you just want to share an experience or something, that's okay too. About anything, you don't have to be what we're talking about exactly.
Absolutely.
But call the number here at the WDXE radio station, and it's 931-766-9393. If I remember it right.
Yes, that's correct.
I think I do. The other thing is I have a seminar coming up. I'll bring this up again at the end of the hour, but it's not till May. It's May the 18th, which is a Saturday. It's going to be here, WLX radio station, 10 o'clock in the morning. So if you want to sign up for that, we've already got people RSVPing for it. So,
oh, really?
We got a pretty good venue here, but last time we had it here, we were just about out of space, which I was sure could never happen. We were out of tables, and we were just putting up chairs without tables. So, anyway, I'll talk about that again at the end of the hour. But
all right, very
powers
good.
of attorney, they have a purpose, and the reason they exist is it's what we call incapacity planning. Now, these come from our old common law. Power of attorney, having somebody act for you is not a new thing. It's been around in our jurisprudence for centuries.
Oh, really?
And basically what a power of attorney does is you give somebody else the authority to make decisions for you. Mm-hmm. Now, power of attorney can be general and it can be limited. In other words, sometimes if somebody will go on vacation and they want to leave their child with a friend or a brother or sister, something like that, and they're going to be gone for 2 weeks. Okay?
Yes.
They can issue a power of attorney that is power of attorney over that child for that particular time period and for particular decisions. Sometimes people go on field trips and they give people a power of attorney to make decisions just specifically associated with that field trip. Okay, so it can be very specific or it can be general. What we deal with mostly is the general one, which covers incapacity planning. Because the reason you want one is this: as you go through life and things happen, whether they're not just medical, other decisions, financial decisions,
yes.
money concerns, buy, sell, invest, you name it. And you make decisions throughout your life. And you decide whether you're going to do this. And every time you make a decision, I'm going to go out on a limb and assume it's always for your best interest when you do it.
Sure.
And so you make these decisions. Now, if for some reason you can't make that decision, now that could be an incapacity or it could just be, suppose my wife and I decided to go, I always want to go to Australia. One of these days I'll get there. If you go to Australia, you're going to be there for several weeks because it's a pretty big place. So I'm going to go to Australia sometime. Maybe I'll go there for 2 months. And when I do, I might say to one of my children, listen, I need you to take care of things for me. Like basic things at the office or decisions with utilities or just the normal day-to-day stuff. So I could, I don't have to be incapacitated for someone to act for me.
Right.
So I give her the power of attorney to make decisions for me. Then the people that normally deal with me will respond to that power.
Right.
But the time we really need it is if you become incapacitated. And you don't have to be old with Alzheimer's, or you don't have to be dementia to be incapacitated. I mean, we have people that have motorcycle accidents and get brain damage, and their cognitive ability is gone.
Yes.
You name it, a stroke, anything. A power of attorney is one of my pet peeve documents, and you really need one at any age because you just
Really?
don't know. I mean, my crystal ball is not any better than anybody else's, so I don't know what's going to happen. But if you become incapacitated, you are going to want the power of attorney allows you to choose now, while you are capacitated, a trusted loved one or a trusted friend or somebody that you trust that's going to look after your best interest, because you're not making the decisions if they're making them for you. So
Yes.
you just don't want to willy-nilly have somebody else do it. You want somebody that knows what your best interest is. Typically it's a loved family member. Doesn't have to be. It can be anyone.
Yes.
Some people who just don't have any ask if they can appoint me, and you can. It can be anybody. Now, I'm probably the last choice, and I don't say that because I'm a bad choice. It's just that when people appoint me and I don't know them like a family member does, I'm going to go with what generically is in the best interest.
Yes.
But I don't really know the person or their morals or values to
Sure.
really be in their best interest.
Sure.
Unless they give me some kind of instructions. But you can ask professionals to do it too. So the whole purpose of the thing is just that. If you want someone else to make decisions for you, and like I said, I've named many reasons why that could happen.
Right.
It's good to have that in place. Now, if you don't have one and you're going on vacation next month and you say, I'm going to leave the kids with our friends over here, so I'm going to give them a power of attorney, you whip one up and give it to them. But the big deal is if something happens to you and you become incapacitated and you don't have one, now you've lost the ability to give one.
Right.
Because you're incapacitated. And to give a power of attorney, you have to be of sound mind
That's true.
to sign one off and give someone the power. Because you are delegating powers that you have to someone else. And the law doesn't take that lightly. So you have to do it in a proper manner.
Yeah.
And it's a big deal to do it. And, of course, they're revocable. If you give someone the power of attorney and you don't like what they're doing or you just change your mind, you can revoke it with a stroke of a pen. Really, all you need to do is revoke it and give them notice that it's been removed.
That was going to be my question. How difficult is it to dissolve or end the power of attorney?
Extremely easy.
Okay.
Like if somebody, there's a lot of ways why you would want to revoke the power.
Yeah.
But let's say it's just not needed anymore.
Right.
And so you can revoke it. It's best to do it in writing.
Yeah.
And what you really are required to do is give the agent notice.
Yes.
Show them that writing. Because until they see that writing, they're not held liable for anything they're doing because they haven't been noticed that they've been removed.
Okay.
Okay, so you want to. That's really all you need to do. Now, if they act after notice, it's actionable.
Yes.
But
How are they kept? Because as far as I know, they're not recorded.
no. Well, there is a time to record a power of attorney. There's one instance where you should record it, and don't let me forget that. I'll bring it.
Okay.
But typically, you just hang on to them because I tell my folks, when we do a trust plan or even a will plan, we always do the power of attorneys, because
Yes.
the trust or the will distributes property after death. The power of attorneys is a power that does not survive death. It is during life.
Right.
You're alive, but you can't make decisions, and that's what they're for. So I tell folks, tell your family that you have them and where they are.
Yeah.
Say, hey, I have a trust plan. It's under the bed. So if something happens to me, your authority resides in these documents. So you need to go to them.
Or better in a safe, maybe.
Well, you know what I mean.
Yeah.
They know where they are. So
Right.
go get them,
Right.
pick them up. Now, when you go to the bank and say, "Hey, I need to deal with some financial issues for my dad," the bank is going to ask the question in one form or another like this. They're going to say, "Well, under what authority are you acting for your father?"
Right.
And I pull this thing out and say, "Under this authority," and they'll look at it and they'll recognize that immediately and say, "Okay, what do you want to do?" Because
Yep.
it delegates that power. It's been executed properly, and so. But the point is, let them know where it is, so they
Yes.
can start acting for you. That's the whole purpose of it. Now, what was that I said I would touch base on?
Recording.
Yes, recording.
Sorry.
You do not have to record a power of attorney. There's no law that says you do for any purpose whatsoever.
Yeah.
However, and you probably know this being in real estate, and I think it's not so much real estate as it is title insurance companies.
Okay. Yeah.
It is very widely accepted, not required by law. I mean, I thrown that challenge out before. I said, I will eat these words. If somebody can show me where in the law it says you have to record a power of attorney, it's not there. I've looked, it
Yeah.
isn't, and there's no such law. But it is very widely accepted that you record the power of attorney if you are using that power of attorney to transfer real estate. So if I'm incapacitated, my son wants to sell a piece of real estate of mine.
Yes.
He can, as my power of attorney. He can call the real estate person, get it listed. He can negotiate the price. He can sign the closing.
right.
He can do all that. But it is, if you run into a title insurance company along the way, either from the buyer or the seller, they're going to balk at. They want to make sure that the power for him to actually sell it is there, and they want it to be recorded. Again, it doesn't have to be. It's one of those things where I don't like it because there's no law that says you have to do it. But then there's the pick your battles kind of thing. You know,
Yes.
just might as well record it. I hate to do that just to make them happy, but sometimes that's just the easier route. And it is accepted. I think 99.9% of the time it's always recorded. So that's the only time that people generally record it. But again, no requirement for it.
Well, the title companies are protecting their interest in doing so.
They are, and they just go a little overboard on protecting that.
They do. They do. I run into that.
To the point of almost unreasonable sometimes. But I get it. It's sort of under law, if something's being done constantly
Yes.
for a period of time, years, it becomes law under what we call operation of law, and this is kind of close to that, really. I mean, it's almost there's no written law that says you have to do it, but it's been done so routinely for so many years that you probably could. It's hard to buck it, is what I'm saying. If you say I'm not going to do it, then they're going to say, well, we're not going to insure the title, or we're going to carve out this exception in the title. So I get it, but
well, while we're talking about power, this may seem like a little bit of a silly question, but it dawned on me while you were talking: is why do we call it? Why do we name this document power of attorney?
I years ago I wondered that myself. And I'm sorry to say, I don't know that I have a really good answer for you, because power of attorney sometimes is referred to as attorney in fact.
Yes.
And what
I've heard that. I've heard that expression.
And best I could tell, the power of attorney and attorney in fact, the word attorney derives from a word from our old English common law, which is like barrister, and it means the power. I mean the fiduciary duty that you're giving to somebody.
Yes.
It's not making you an attorney,
Right.
If John Doe gives Jane Doe his power of attorney, I mean, neither of them are attorneys, so nobody's an attorney. It's the passing of this power. So I don't have a good answer for that. I don't know.
It carries with it the authority to act on that person's behalf.
Sounds like something they named just so that lawyers would understand it.
I guess.
and we don't, right? But I mean, you can, sometimes you see the person named agent, which is my preference, or they can be called the attorney in fact, and the person writing it's called the principal. He's the one the giver of the power. Now, let's talk about this a little more, and that is if you don't have a power of attorney.
Yes.
And something happens, and you've now lost. So let's say, here's a good example. You don't have a power of attorney. You say, I don't need that. I'm in my 30s. I'll worry about that when I get older and get Alzheimer's or something.
Yeah.
And then you have a motorcycle accident, you have brain injury, and you're incapacitated. You're in a coma or something like that. Now you've lost the ability to sign one and give it. You can't give one at this point because you're not sound mind anymore.
Right.
Now the problem with that is, let me just say this: if you would have done a power of attorney, they're very inexpensive. Okay, so if people come to me and husband and wife, they want reciprocal power of attorneys. I mean, the cost is somewhere, I don't know, maybe $250. It's very cheap.
Right.
But if you become incapacitated now and you don't have one, now you have a wife, maybe you got some young children, and she can't make these decisions because being married does not give you the authority to act for your spouse. That surprises people. But I'm the wife. I should be able to do that.
Yeah.
The answer is no. If it's a joint bank account, yeah. But if it's his, no. So you have to have this authority. Now you've got sort of in a pickle because how do we do it? If he's the only one that can give it and he can't give it, how do we get it? Well, there's one remedy at law and one remedy at law only. That is called a conservatorship. Now, everybody's heard the term conservatorship. And when you hear that term, a good way to remember it is it's a court-ordered power of attorney. It's the same thing. But you got to go to court to get it because the court is the only entity that has the jurisdiction to give a power of attorney involuntarily.
Okay.
And I say involuntarily because the person can't do it.
Right. So
they're going to do it for him.
Okay.
And so and we need to have that power because otherwise it's just like a standoff. We can't ever get there.
Right.
So, but the thing with a conservatorship, it is very expensive. It is very expensive. It takes about 5 or 6 months to get through it. I ran one through once in 30 days. We had to have it done for a fair hearing in 10 care. And the only reason I got it done in 30 days is because the guardian ad litem and the judge, the guardian ad litem agreed to go fast, and the judge agreed to hear the hearing in a different county. It was like a Giles County case, but he agreed to hear it when he's sitting in Murray County.
Oh, yeah.
Just to get it done for us. I mean, I had all this help getting it. Otherwise, we could have never done it that fast.
Wow.
But it's typically 3, 4, 5 months to get there. And you're looking at, I don't know, between, there's more than one attorney that gets involved. So you're looking anywhere from, I don't know, $4,000 or $5,000 upwards to 10. I typically see them in the $7,500 range compared to what it would cost to just come in and do it while you're
what is the typical cost of getting a POA done?
Well, like I said, if your husband and wife, it's typically about $250.
Yeah.
I mean, very, very, very inexpensive documents.
That's a whole different ballgame.
It is a big different thing, and you'd be wishing you had if you get to that situation.
That's right.
And it's a drawn out process. I mean, when you file power of attorney, here's the way it works. If somebody comes to me and say, so and so's incapacitated, can't make decisions, I need to be acting for him. So we draw up a petition, we file with the court.
Yes.
Well, put yourself in the court's shoes. They're not going to take our word for it.
Yeah.
I mean, just saying it, us saying it doesn't make it so.
Yeah.
So, and one of the reasons for that is, it's a vehicle for abuse. I've seen this before. Somebody would say, Aunt Gertrude needs a power of attorney. I need to be taking over her money and her finances. And then we look into it, Aunt Gertrude's just fine. She just has a lot of money. she's sharp as a tack, right? And so it could be a vehicle for abuse. So the court says, well, we're not taking your word for it. So what we're going to do, we're going to appoint a guardian ad litem. That's a Latin term, but basically they're going to appoint a licensed attorney.
Yes.
His job is to represent the ward or the respondent. Okay.
Yes.
So that person will go and talk to the respondent or see what's going on.
Interesting.
See what's wrong with him and see if he's able to be his own decision maker or not. Then he'll look into the people in the petition names as who, the petition will say, okay, the wife is throwing her hat in the ring to be the agent. Okay.
Yeah.
So he'll check the wife. He'll talk to other family members to see if the wife is the best person to be there, and see if any other family members object to that or they think they ought to be there. Meanwhile, on my side, if I'm the lawyer filing the petition, we're sending waivers to everybody and saying, hey, look, Jane wants to be the power of attorney. If you have an objection, you need to let us know so we schedule time for you to come in and be heard and try to put on proof as to why you should be the power of attorney. If not, can you sign a waiver saying I don't object to Jane being there and I don't want the job, and stuff like that. So there's a lot goes on, and the guardian ad litem looks into all that. Then the guardian ad litem will give an independent report to the court. Usually I know the attorney, but he's not going to side with me just because he knows me. He's going to be completely independent. He gives that, and the court will give that quite a bit of weight.
Yeah.
Because his job is to look out for his best interest. I've seen it go both ways. I've seen him come back and say, yeah, you're right. That's pretty much a slam dunk. He needs a power of attorney, and she's the best person for it.
Yes.
And I've seen other times, the person doesn't really need it and doesn't want it.
Right.
And then, so you just don't go forward.
So there was a motive behind that.
Usually that's the problem with that. And the court has this check and balance system to make sure. But the system doesn't happen overnight. And meanwhile, this wife of the person that's incapacitated can't pay bills or whatever. I mean, if they have a joint bank account, they can. But I mean, there's all kind of issues. Insurance money, they can't get past certain things until they have the authority to act for that person. So that's why it's a pet peeve of mine. You need it at any age because anything can happen. And we're not just talking about you could die at any time. That's always out there. But you could become incapacitated at any time.
Yeah.
Even for a short period of time.
And that presents its own set of problems, which this will help to alleviate.
Oh, it's a lifesaver if you got one. They're simple to do. From time to time, you name in there your agents, who you want. And you can name several so that you don't run out. I would advise people, let's name 2 or 3. Let's not run out. Because if you name one person, let's say you name your wife on yours. Yeah. And for some reason she either predeceases you or she becomes incapacitated herself but can't do the job, right? Or she's just doesn't want the job or something. Right. Then that fails and goes to the next one. Well, if there is not a next one, because you've only named her, that's viewed under the law as if you don't have a power of attorney. So off the court you go for a conservatorship. So we named 2, 3 people.
That's interesting. I hadn't thought about that. But
we named 2 or 3 people because, and I know when you're getting down to your 3rd or 4th choice, it's not your ideal choice, but a non-ideal choice is better than no choice. Yeah. So if you have a power of attorney, 5 years later, 10 years later, you look at it, you say, you know what, I named these 3 people. The first one, he's pretty in bad health himself. He's probably not a good choice. I mean, you can revisit these from time to time, and the only thing you really want to change in a power of attorney is who the agents are, or the order, or maybe add new ones or take away old ones. And we don't really modify this document. We just simply do another one. They're pretty simple to do.
Right.
So that's how it works. But now let me talk about what's in the power of attorney. Because it's a pet peeve of mine for other reasons than just people needing it all the time. And the other one is they need to be written right. I've reviewed a blue million of them. And if some of them are very, very short, and there's a problem with that. Now, I'm not advocating having something that's not brief, or something that has a lot of bulk to it. Brevity is fine under the law if it's okay, if you're not missing anything. But, we are what we call a General Durable Power of Attorney Act state. And we adopted that. And the statute lists general powers. Okay. And a lot of times you'll see a power of attorney that says something like this. It says, very short power of attorney, but somewhere in there it'll say, I incorporate the powers under the statute by reference. And the statute itself says you can do that. And then it includes all those general powers that were listed, right?
Right.
Even though they're not in the document. Now, there are also powers. Well, let me back up. So, and you also see language in a power of attorney that says, my agent can do anything and everything I could do. Sounds all inclusive, doesn't it? I mean, it just sounds like anything and everything sounds like anything and everything, right?
It sounds like it.
Well, it's really kind of not, because in our act we've got these powers called enhanced powers. I call them superpowers.
Okay.
But they're enhanced powers, and they're powers that they're considered non-delegable rights. And what it means is, if you want your agent to have that power or any of those enhanced powers, they must be expressed in the four corners of the document. If it's not listed there, they don't get it. Even if you say anything and everything, it doesn't include those. Now, here's a good example. We do a lot of trust work and a lot of trust plans, right?
Yes.
Both revocable living trust and asset protection, stuff like that. Well, if you would, a good power to have, and I was here talking about a court case maybe a couple of months ago where the court said, hey, on this very issue, if you think it's a good idea, and I think it's a good idea, that we put in your power of attorney that the people you're naming can not only deal with trust that you already have, they can actually establish and make a trust for you. Because I talked about a court case a couple of months ago where somebody made one of these asset protections for mom using the power of attorney. And it got to court, and the court said, yeah, if it says in the power of attorney he can do it. And they went further and said, that's definitely within her best interest to protect her property from long-term care. Okay. So, but that's one of those enhanced powers or superpowers. So if you don't put that in the instrument, your agent doesn't have it. And that's exactly what that court case said. That was challenged. Maybe I'll go over that again one of these days, because that was an excellent case came out of our courts.
Okay.
And the appellate courts, the issue was he made this asset protection trust. This trust that we do all the time. The asset protection trust for protecting property from long-term care, because mom had a fair amount of assets.
Right. And
the son, who was the POA, set that up for her. The daughter objected. I don't remember why, but she said he didn't have the power to do that. We got the courts. The courts simply said this. They said, well, this is the question before us, and here's how we're going to resolve it. We're going to look at the power of attorney. If it says he can do it, then he can do it. Okay? Now, if it says I incorporate all the powers by reference, they're going to go and see what those powers are that got incorporated by reference. If it's there, he's got it.
Yeah.
Well, that power's not in the general powers. Okay? But it is one of the enhanced powers. And it was in there. It said he had the ability to establish trust, both revocable and irrevocable, and fund them. And the court said, okay, the first question we're going to answer is yes, he had the authority to do that because the actual power of attorney said so.
Yeah.
And they quoted that actual paragraph.
Yeah.
They said, but there's more. When he did it, it said he had to act he always has to act in the principal's best interest.
Yeah.
And they went on to say, which was I thought was great that they said this. They wanted to say making this kind of trust for somebody to protect their assets from long-term care is definitely in their best interest.
Yes.
So if you extrapolate that now to not being incapacitated and you do one for yourself, if it's definitely in the best interest of somebody that's being done for,
yes,
it's incapacitated. It's definitely in your best interest if you want to do it yourself. But
that's correct.
The point is, these powers have to be in there. I think filing tax returns is one that has to be in there. The IRS has their own power of attorney form. I forget the number, 8609 or something. And they're pretty picky about letting you file a tax return for somebody. They'll let you do it with your power of attorney if the language from their form is in your power of attorney.
Oh, really?
Now, that's not one of the ones in the code, so you got to put it in. Stuff like that. So when you say, again, these, I call them superpowers. If they have to be written in the document
Yes.
for you to pass that power. Otherwise, you cannot. And banks understand that. So they know when it's not there, and you argue with them and say, but it says anything and everything he can do. And it's like, well, I know, but that's legally not the way it works. So, my power of attorneys are not short. They're like a small book, and they need to be, because I have dealt with places where I see where not putting it in the document fails. And now, if I'd always take the position, it's better to have a power and never use it than it is to not leave one out and have to go to court to get it, if you can get it. Now we're dealing with adding a power to the power of attorney, which is harder to do than the conservatorship. It's a limited thing to do, but it requires a lot more explanation. So, and again, a couple of instances I've had over the years, I had power of attorney, and it's kind of long. 18 pages, something like that. List all these powers. Just spells them out. Just spells them out. I don't say incorporate the powers into the code. I go ahead and waste a little paper and a little ink and put it in there. Now, somebody once said to me, they said, here's something here. Can you take these out? And I said, well, tell me why you want them out. I just don't ever see them applying. I said, I got you. It sounds pretty remote. He says, yeah, they don't need to be there. That's never going to apply. I said, I'll tell you what. If they're never going to apply, why don't we just leave them in?
Yeah.
Because if they ever do apply and they're out, we got a problem.
Yeah.
And I say that because that happened to me one time. Had a gal, she was in her 40s, and we always put words in there like dealing with afterborn children.
Yeah.
Actually, this was in a trust.
Yes.
This was not in a power of attorney. It was in one of my trusts that said, I'm going to leave my property, but we always say, we include afterborn children because they're not in existence when we wrote the trust.
Yes.
And she said, I'm not going to have any more children. I can't have children. I'm not going to have any. I want that taken out. I said, well, it doesn't hurt anything to be in there. She goes, I don't want it in there. So she made a big deal of it. So I, against my better judgment, took it out.
Well, no.
3 years later, she calls me that she got remarried and they adopted.
Yes.
And now it's not there. And now, so my position is this. If you read a power in there and you say, there's no way that would ever apply to me. You know what? It's a little paper and a little bit of ink. And if you never need it, so we wasted a little bit of paper and ink. I mean, it's really, let's just leave it in. I mean, in my experience, when you deal in law, less is better. You know what I mean? When I used to do criminal defense work, and you get up there in front of the judge, I'd turn to my guy and say, don't say anything. And if he asks you a question, give him a yes or no answer. Do not. Please, don't elaborate. Do not have an urge to explain. Less is better. Just give them a yes or no. In this area of the law, more is better. So just throw it all in. If we ever need it, it's taken care of. If you don't ever need it, it's just a wasted power.
We run into that with a lot of our contracts and documents that we use for real estate sales. There's a lot of language that doesn't apply to the deal that we may be doing. And I'll have people every once in a while say, hey, why is this in here? This is not, it just doesn't apply. But it's there for when it does apply. So we do our trust. We have a whole section in trust about underage and incapacitated beneficiaries. People say, I got 5 kids. None of them, they're all grown up. Yeah.
None of them are incapacitated. Why is it 5 pages of this here?
Yeah.
I say, well, do you remember back when you left it to your 5 kids in this document? Yes. And I ask you, what if one of your children predeceases you? Where do you want it to go? Well, I want that share to flow through them and go to their kids. I said, okay. So we don't know if we're going to have underage beneficiaries or not, do we? Because if one of these predeceased and it flows to his kids and it's per stirpes and maybe flows from those kids, I mean, I guarantee you we're going to hit an underage person here at some point.
That's right.
And when we do, we got a problem because underage people will have to inherit and can't own property, or at least they can't own it until they're of age of majority. Right. They own it, but they can't have it or use it. And we got to deal with that. This doesn't hurt to be there because it happens a lot.
Yeah.
So, when you look at it, it's not all just legal mumbo jumbo, and it's there to be impressive. If it doesn't need to be there, if it truly doesn't need to be there, I'll take it out.
Well, one of the things that has really struck me during our conversations, and the more I've learned about this, is that this is really about the what ifs.
Oh yeah.
From the get go, from whether it's wills or trust or powers of attorneys, it's all about the what ifs of life that happens.
Boy, that don't hit the nail right on the head. It is the what ifs, and I'm in the what if business.
You're the what if it happens.
And I'll tell you another story. I had a couple, and they did a trust plan, and in their trust plan were powers of attorney.
Yes.
Well, a couple of years later, the husband got sick and actually became terminal.
Yeah.
And he was up at Vanderbilt. And I get a phone call one time from the legal department, lead counsel of the legal department at Vanderbilt.
Oh, wow. Okay.
And I'm thinking, okay, wonder what he wants, right? He wanted to know if I could send them a copy of her power of attorney that she has for him.
Yes.
I said, well, I'll be glad to do that. I sent it to him, and after I sent it to him, I'm thinking, gee, I hope that's okay. I hope they're all right. I hope my they're going to pick, army of attorneys are going to start picking apart my power of attorney, right?
Yeah.
And so a couple of days later, I can't remember how it came about, but we were talking again, and I asked, is everything okay? And this is what he told me. He said, oh, yeah. He said, it was fine. He said, she needs to do something. And we are used to not seeing the power in powers of attorney. And we're going to advise her to go to court to get this power, but we looked at yours and it was there. Said,
Yeah.
so she's got it. So I said, no, there's nothing wrong. We're just used to it not being there.
Yeah.
So that tells me throwing in the kitchen sink is no harm whatsoever. And I won't go into it because it was personal, but it was a very unique power.
Wow.
One that you really, if you were looking through these and say, which ones can I toss out? That would be one you give some thought to.
Yeah.
But we left it in because, like I say, it's better to have it and not use it.
It's the what if.
Yeah, than to need it and not have it.
Yeah.
Because that would have been a problem because we're dealing with Vanderbilt, life and, what's going on with a terminal patient. And so mine have undergone muster and have survived. So I stick with what I know works.
Well, that's great. That's great. We touched on this a little bit, and I know this to be true with powers of attorney. They're only effective as long as the person being considered is alive.
That's right.
And so explain that a little bit because, people might think, and I have this happen, someone who has a power of attorney for someone and they're deceased. And we have to kind of go over why that's not
I've been there too.
Yeah,
I've been there too.
there.
Folks say that, and
Yeah.
and some technically it expires at death.
Yes.
Now, you can sometimes get away with stuff in a small town, Pulaski, Lawrenceburg. The banks know the person,
Yes.
stuff like that. I mean, then they kind of let them write checks after death on the account. I mean, that
Yes.
happens, but technically, that power it doesn't exist at death.
Yes.
So you kind of when you look at powers, you kind of like draw this line in the sand or on the timeline at death.
Yes.
While you're alive, somebody can make decisions for you under that.
Yes.
After death, well, there's not so many decisions now to be made for you, but now the power changes to either the executorship of a will, administrator of an intestate estate,
Yeah.
or the successor trustee of a trust. Now that person is taking over, making all the decisions, but they're all after death decisions, which are a little different than during life decisions.
Mm-hmm.
But now they have the power, but the power they're exercising to do it has switched. Power of attorney. So let's say I name my son my power of attorney, but he's also the first up on the successor trustee of my trust.
Yes.
He's making decisions for me. I kicked the bucket. Now he's dealing with my estate as my successor trustee.
Yes.
So his power switches at death, and so that's what goes on with that. Now, again, can he go to the bank and do the exact same thing with one power that he can do with the other? The answer is yes, and that's why sometimes it's kind of looked at.
Yes.
But if you deal with big banks like Wells Fargo, Bank of America,
Yeah.
places that are everywhere,
Yeah.
they don't. They go by the rules. They don't. You'll hear a local bank. I won't name them, but you know what I mean. They know who you are. They know
Yes.
your wife's your wife, and they know you need to do this because you've been doing it every month for the last 20 years. And
Yeah.
certain things slide through. But again, it's kind of a liability thing. That's
true.
When you get to these banks, they don't want to take a chance. They don't want liability.
That's
and so
right.
they stick to the rules, but in a situation like that, they're pretty comfortable with it, and so they just kind of do it.
Yeah.
It's not entirely correct, but if you don't have a complaining party, then no harm, no foul. But technically, it is for. I agree with you. We tell people this expires at death. There's other powers, but now the problem is if you don't have any of those things, there is no power at death.
Yes.
Unless now, if you don't have anything, now you got that intestate succession where you have no will, no trust. And again, it's court appointed. You got to go to the court, and they'll pick who's going to be the. You have a will. It has to be. I told you, a will has to be executed, so you have an executor. If you have an intestate estate with no will, it has to be administered, so you have an administrator.
Yes.
And so in that case, the court will decide who the administrator is going to be.
Yes.
people will throw in their hat and say, "Well, I'll do it," or "Here, I'll do it."
Right.
And then the court will decide who's best person to do
Right.
it. But it's court intervention, and it takes that. Anytime that happens, it takes time.
That takes time.
Because they want to pick the best person for the job, and they don't know any of them from Adam. You know what I mean? They have to have people have to come in and show the court why they're the better person as opposed to other people that want the job. Even if you're the only one throwing your hat in the ring, doesn't mean you get it.
Not to mention just having to wait on the court system calendar anyway.
Oh, sure. I mean, there's always that. There's always that. It's painfully slow.
Painfully slow. That's right.
And I've, in all my years, it's hard to figure out why. I've been in some cases where there are like 4 and 5 attorneys, and we sit there and say, okay, we're going to pick a date for whatever. We'll be there for 20 minutes. 'Cause every time a date comes up,
Yeah.
I'm okay with that. I'm okay with that. No, I've got a deposition that day. Okay, then another date comes up. That sounds good to me. Just no, I'm going to be on vacation that time. I mean, it's like 20 minutes till we finally hone in on some date that's way out in the future. Okay,
Yes.
That everybody's okay with.
Yes.
So there is always that scheduling stuff with courts, but it sometimes just amazes me how things they drag on because of that.
Yeah, they do. Well, everybody seems to be so busy anyway, and then trying to fit a date in that everybody can agree on.
Well,
I can imagine that it drags out. I was going to ask you this too: when you do the wills, trust, you've got all the systems in place for, let's say, a family, a couple, or whatever. It happens so often, and divorces happen.
Yep.
How does this affect the world of estates and estate planning? And I know it's probably all over the board, but what do you do?
Well, it does. It does affect it.
Yeah.
Even if you have a simple situation like reciprocal wills.
Yeah.
Husband and wife have a will that basically, I call it a reciprocal will. It basically says, I leave everything to my spouse.
Yes.
But if she's predeceased, then it goes to equal shares to my kids.
Yes.
Something like that. I mean, you can have other distributions, but
Yes.
And then the spouse says the same thing, right?
Yes.
And so, of course, if you get divorced, when you get divorced, you are no longer enjoy the title of spouse. Spouse is a legal term.
Yes.
And, spouse, surviving spouse, that's a legal term. So, and again, the only 2 ways out of a statutory marriage, you have a statutory marriage, there's only 2 ways out of it. That's either divorce or death.
Yes.
And so if you're ending this marriage by divorce, you're no longer the spouse at the end of the divorce. And so you got to deal. You probably named the spouse in this plan. If it's a trust plan, they're more than likely joint trusts.
Mm-hmm.
So we do have to do some modifications now. We got to convert these joint things into individual stuff. In a will, you just have to do a whole new will.
Yes.
Take the spouse out, and let me tell you something. You definitely want to change it. Now, if you say I leave my property to my spouse, and if they predecease me to my children, the divorce will fix that because she doesn't have the term spouse anymore.
Yeah.
But if you say I'd leave my property to Mary Jane, and then if she predeceases me to her children, and Mary Jane's your wife, and then you get divorced, and you never change your will, and you die 20 years later, guess who gets everything?
Yeah.
Because she is named. You didn't call her the spouse. You named her by name, and you didn't change it. Now you're gone. The court's going to assume whatever was in the instrument at your death, that's what you must have wanted to have happen.
Yeah.
And everybody and their brother will complain and say, well, they've been estranged for 20 years. She's been living in Washington State. She doesn't even know what he has. Why should she get everything?
Yeah.
She gets everything because you said so in the instrument and you got divorced from her. And of course, the attorney should have advised them that they need to deal with stuff like that, but they never did deal with it. I have seen that happen. I saw it happen in a case here in Lawrenceburg years ago. And guess who will surface when they're the named person in a will? Okay, I'm telling you, it's like I could do it with my eyes closed. They will. That person will surface.
Yeah.
And when they find an attorney that says, technically you get everything.
Isn't that amazing?
Then I don't know. Maybe the person will maybe you'll get a magnanimous person who says, you know what, I've been estranged. I don't deserve any of that. Let it go to the kids.
Yeah.
But more often than not, it's something else. That's just the nature of people, I'm sorry to say.
Well, that's true.
I mean, not all.
Not all, but a lot.
But it's such a simple fix. If you're going to get a divorce, I mean, you like women can sometimes change their names back.
Yeah.
You have to do things. That's just one of the things that needs to be done. If you have a joint trust We can sever them into two individual trusts, but now we have to deal with the joint property because that will have changed as a result of the divorce.
Yeah.
Because in divorce, they divide the property.
There's a lot of cleanup work on that.
There is. So, we can't ever, but nobody goes into this stuff anticipating a divorce.
No.
And you shouldn't.
No.
But I mean, if it happens, it's just something, it's another thing you have to deal with.
Sure.
So I would not do it because of that. You don't. Let's say, I'm not going to do this because in case I get divorced, I'll have to change it all. I mean, that would not be a very reasonable approach to it.
No.
But if it happens, again, it's just like you said, it's something that has to be dealt with.
Right.
Because everybody's status and circumstances have changed. And if you get remarried, you really ought to revisit it because now you want to have the same kind of protection for the new spouse.
Yes.
Because, the whole reason you do the planning is, well, how's my spouse going to get along if something happens to me? Or how are my children going to survive if something happens to me? Or something along those lines. The what if again.
It's all the what ifs and the things that need to be thought of. And that's where someone like you who that has the experience and have seen multiple circumstances can help you think through the process and think through the what ifs and then be able to address them in a way that is legal and protective of what your wants are.
I have recently got a phone call that I had with someone, and they were telling me that we got like 3 kids. Dad had some land,
Yes.
valuable land, and the kids had a lot to do with the land. I don't know. I think they were working. It was kind of a family farm.
Yeah. And
they weren't too crazy about his wife or his surviving spouse, but he passed away with no will.
Oh yeah.
And they said, he has no will, but I mean, we know that the land goes to those kids, and because he passed away, and they were calling the thrust of the call was, how do we divide it among the 3 kids?
Yeah.
I said, well, you're missing a player. If you don't have a will, the state of Tennessee writes one for you, right? It's called the laws of intestate succession.
Yeah.
And they've already decided who your heirs are and what percentages they're going to get. And the law looks to 2 people when someone dies. It looks to see, do you have a surviving spouse and do you have any natural descendants? So here we had 3 natural descendants and a surviving spouse. And so without a will, at the death of a first death in a marriage,
Yes.
it says for the spouse, they get 1/3 or up to a child share.
Yes.
Okay, now, the only time it's ever anything other than a third is if you only have 1 child, because then you get a half, which makes it up to a child share. But as soon as you have 2 children, then the spouse gets a third, and the other 2 split the other 2/3. Now, in this case, the wife got a third of all his property. Now, the farm is in there.
Yes.
And the 3 kids split the other 2/3. So each kid got 2/9.
Yes.
And the wife got a third, or 3/9.
Yes.
And so, and they were just shocked when I told them that, almost to the point of that I don't believe you.
Yeah.
I said, well, you can believe me or not believe me, but I'm telling you that's my advice to you.
That's the way
That's
it'll
what's going
work.
to happen. Now,
Yeah.
I don't remember. It seems to me that the wife was pretty reasonable and wanted to let the kids have it or something like that. Because
Yeah.
it was a blended family, and that's where that kind of happened.
Yeah. Yeah. And
This was
and that happens so often. I mean, that's so much a part of our society now. There are a lot of blended families.
I mean, if mom and dad are still married and the kids, and some goes to mom, I mean, it's usually, I'm going to say 99% of the time, nobody cares. It's all the same family.
Right.
But this was blended. These were children of the deceased, and the wife was a new wife. And, sometimes there's some animosity there. And so they were really concerned, and they should have been. And there's nothing to do. There's nothing to do about it now. Now, that person can disclaim or waive their inheritance. They can do that. Of course, that's not always the solution either, because if you disclaim,
Yes.
if somebody leaves you money and you say, I don't want it, I mean, or property or something,
Yeah.
you can disclaim an inheritance.
Which would be pretty rare, by the way.
Sometimes we do it strategically. You know what I mean? Sometimes we do it on purpose to get the result that happens.
Yes.
And what happens is it doesn't. Here's the danger with that. You got to think it through, because if you say I'm going to disclaim property, the law doesn't say, well, it just stops and goes to whoever else is there.
Mm-hmm.
So you got 3 kids and this wife, right? Let's just say the wife says, I disclaim the property.
Yeah.
It doesn't go to the 3 kids. The law says if you disclaim property, it passes as if you had predeceased.
Oh no.
Yeah. How about
that's a whole other can of worms.
How about if mom has children of her own in this blended family?
That's another can of worms.
Yes. Now, so I mean, sometimes we do that to make that happen because that's what we want to happen.
I think you lawyers have made it complicated on purpose.
Well, the legislature made it. The legislature made it complicated on purpose, which are a bunch of lawyers, right?
They're lawyers. That's right.
But no, but so it's not. Please don't take a common sense, street vernacular approach to how this stuff works, because it doesn't.
Yeah.
I mean, you got to think this stuff through.
Yeah.
When you don't have a will and they write it for you, it very often is not what you would normally do.
Yeah.
And so.
How does your practice, and this is kind of, I guess, an off the wall question. I don't know, but the term family law hit me while you were talking, and so this is a big aspect here of what you do, I guess.
Well, family law is pretty much defined. People that say they practice
That's
family law.
a big umbrella, I guess.
It's mostly things like divorces, guardianship, juvenile child custody stuff, that kind of stuff. Family. That's typically what family law means. Estate planning sometimes has to deal with the issues of family law, but I mean, we don't do the divorce or we don't do the custody battles or that stuff.
Sure.
Yeah.
Okay, so that's a different practice.
I mean, we know. I can discuss the effect of that.
Yes.
We're talking the effect of a divorce or the effect of custody on minor children.
This is where we were, yeah.
But it's kind of a separate area of the law. People that practice family law do not do estate planning.
Yeah.
And I don't know, maybe some estate planners do family law, but I don't. I never did much divorce work and didn't like it. Yeah. You've heard.
It's not a pleasant area of law practice, I wouldn't think.
Well, I don't know. Some divorce lawyers might disagree with me, but I never liked doing it. The law is very nebulous, in my opinion, and you just kind of get up there and trash the other party. And never. I mean, somebody will probably be offended for me saying that, but whatever it was, it just wasn't what I enjoyed doing. And so I did a few what we call uncontested divorces, where the parties said, you know what, we're calling it quits. We both agree on exactly what to do with all the property, what to do with the kids, and we just want to sign an MDA and be done with it. Yeah. I did a handful of those, but other than that, I didn't dabble in it too much. I didn't like the ugliness that happens because they get ugly between families.
They do,
and sometimes families are just. Well, I won't get into it, but they just hate each other for life, and it's a shame. And
that's a
kids
shame.
are involved and all kind of stuff.
Well, it's not a good thing, and hopefully for most people it can be avoided, but it's not. It happens. Yeah.
I'm not saying there's not a need for folks to do family law. It's just not.
Yeah.
It's just not what interests me.
But it affects your estate plan.
It can. It sure can.
It affects all that. It sure does. We've got about 8 minutes left, and I know you've got some events maybe planned in the future. Is there seminars coming up?
We have a seminar coming up. It's not right away.
Yeah.
Because I mentioned before that we're spreading those out a little bit.
Yes. Because
we go to so many places. I don't mind doing them, but when we start doing them so often, it affects what I get done. So we're kind of thinning them out a little bit. But the next one coming up, and we just started with this last one. Which we did earlier this month at Giles County over in Pulaski.
That's
right. And the next one's going to be over here at the radio station. But it's not until May, so it's 2 months from this last one. It's going to be May 18th, which is a Saturday. And on Saturday ones, we always do them at 10 o'clock in the morning, called Will's Trust and Nursing Home. We do it in the back of the building here at the WLX radio station where this used to be a bowling alley, and it's a big, long building. In the back, there's a couple double doors in the back, and I often tell people, if you want to find where it is, there's no sign. You call it the Country Cafe, but there's no sign, and it's not really a cafe.
It's not really a cafe.
I've had some people say, well, we'll just stay there and have lunch afterwards. It's like, well, it's not that kind of cafe.
Not that kind of cafe. It's not.
Next time I'll tell them, yeah, sure, Jeff will come take your order. Yeah. Jeff and LB will come take your order and cook you up a burger.
We'll bring you something from McDonald's or something.
But I tell people, you guys got the tallest tower in Giles County.
Yes.
Lawrence County.
Lawrence County, yes, sir.
And it's like 350 feet tall. And so where that thing hits the ground, there's a set of double doors.
That's
so
right.
if you find that and come on in, you're at the right place.
Yes.
But that's going to be May the 18th. That's, May, this is March.
Yeah.
May the 18th.
It'll
Saturday,
get here faster than you know.
It will.
Yeah.
And then the next one will probably be the second month after that. And I'm not sure where that one, but it's probably not going to be Giles or Lawrence. It's probably going to be Franklin.
Right.
Or Marshall, or Murray.
And a lot of people may not know that you are on one of the Nashville stations and have a regular spot.
I do. This show, it's a little more structured when I do that. This one I like to keep as a call-in, and people can call in, kind of keep it loose, and just talk about it. Up there, it's a little more structured. We deep dive into some stuff, but it's got the same name, Bulletproof Estate Planning. It's every Sunday night from 8 to 9.
Sunday night from 8 to 9.
Yeah, it's I use my theme song. I'd like to get that music over here so we can
We got to
use it
get
here.
that. I don't know why we
I just
don't.
use that song by the Byrds called "Turn, Turn, Turn."
Oh, yeah.
Yeah, and it's just I like it. For everything there's a season.
That's right. That's a great song.
And planning there's a season for planning. So, but yeah, we do that show, and I have a lot of listeners for that.
Yes.
I mean, far and wide. I get calls, I get visits, I get people that come to the seminar. I get emails from people that are really several counties away.
Yes. Well, that's a big station, bigger than us. And,
It is.
Yeah.
And they're a little more difficult to work with sometimes. I mean, you have commercial breaks.
Yes.
And they tell you, you're in radio, so but they say, okay, we get these commercial breaks, and they're soft breaks here and here and here. But at the end, that's a hard break. So if you're still in the mid-sentence, when you hit that time, you're cut off, right?
Yeah, exactly.
Well, they're not as soft as they say they are.
Yeah.
Because you get a producer up there that controls that for you.
That's right.
And if I'm coming up on the time, he's flashing something in my face that says, let's
Now,
wrap it up.
do you go to the
break,
studio?
to
Do you
break.
go to the studio up there to do it?
I can do it from my office because
That's
during
good.
COVID we did a lot of it from the
Yeah.
remotely.
Yes.
And so I still do it both ways.
Okay. I wondered.
Yeah.
Yeah.
I'm gonna. Which reminds me. Well, we'll talk about this afterward. I'm going to be out all next week, and so we'll talk about what we're going to do Friday.
Okay.
So,
we can do a.
But yeah, it looks like we're
we can do an encore or something.
Pierchoski State Law, Pierchoski Law Firm, Pierchoski Elder Law, 931-363-7222, or estateplanstand.com. Call me, ask a question, come to the seminar. Anything you want to talk about, I'm more than happy to talk about it.
Yes.
So we let that sneak up on us, didn't we?
Yeah,
Looks like
we're-
it's
actually-
7:56.
No, we're still okay.
I was looking. What was I looking at?
Yeah, it's okay.
Okay.
We still got a couple.
We
of
got
minutes.
3 minutes. That's right.
Yeah, we're a couple of
I
minutes.
looked at that clock behind you, and I thought it said for something there 3:29, and I
That-
thought that was 7:59.
That clock is an hour off.
Yeah.
But the minutes are right on it.
That's
So,
right.
Anyway, we have to kind of calculate when we do that.
But I get some great reviews on my seminars. The last two I did one here in Lawrence County. We had a capacity crowd. We had over
Yeah.
70 some people.
Yeah, you did.
They were parking across the street in the trooper's place. I mean, it was Saturday, so it was no big deal. But people came from far and wide. And we had one in Pulaski just earlier this month, the 17th of March, I think.
Yeah,
And and that's a big venue too.
it is.
But it always warms my heart when people come up to me at the end of the seminar and tell me, say, this was so informative. I learned a lot. I'm so glad I came to this. I mean, that's exactly the result I'm going for.
That's perfect.
As a matter of fact, the one that I did it every now and then, and the one I just did at the theater, the Star Theater, was when I was done. I kind of asked the crowd. I got the end of it, and I kind of said, did this help? Because I have a slide that shows when the next one is.
Yes.
And I invite them, if you know anybody else that would like to hear what I'm talking about, here's when the next one is. And I always ask, did this help you folks?
Yeah,
And I
exactly.
actually got applause. So that just warms my heart when we do that, because people are so thirsty for this knowledge. It's not out there. You
Yes.
go on the internet, and
That's true.
it's all over the place. Everybody and their brother chimes in, which is one of the bad things about the internet.
Right.
But and some of it's correct, but it's hopelessly incomplete, and some of it is just plain wrong.
Yes.
And people sometimes act on it, and they end up going the wrong way. Now we can usually fix that, but still,
Yeah.
that's not the best place to get this kind of information or
Right.
any legal information. It
Right.
can kind of give you an idea how things are, but everybody thinks, especially when you're dealing with long-term care,
Yeah.
everything out there is wrong.
Yeah.
I mean, it just is.
Right.
Because people feel like there's nothing you can do, and there's tons we can do. So
Well,
don't
I
forget
have
that.
certainly learned a lot, and I know that our audience has. And of course, you've got opportunities with the seminars. Stan Pierchoski, everybody. Pierchoski Law, Estate Plan Stan, better known as.
That's right.
363-7222 is the number, and we would encourage you to try to make plans to go to one of the seminars there. And Stan, so next week, we may have an encore or something like that.
Perhaps.
Going to be traveling some.
I am, and the only other option would be phone in, which for an hour show may be a little not ideal.
we'll plow
I
through
think I did it during Snowmageddon.
Yeah, we did.
We called in on that one.
We did. Well, until next time, my friend.
Yeah, always a pleasure, Jeff, and always look forward to being here. So we'll be back next Friday morning from 8 to 9 with Bulletproof Estate Planning with your host, Estate Plan Stan.
There you go. Thank you, buddy.
7 AA and W237FD Lawrenceburg. Broadcast services of Prospect Communications.
1 year